anti-terrorism initiatives, for example, enhanced screening. It was cybersecurity people, law enforcement people pushing for more surveillance, more monitoring, more government information, and the privacy advocates and civil liberties people pushing back and trying to carve out more room for privacy. So the traditional model has effectively emphasized tensions. It's been security against privacy as an antagonistic model, security but privacy. Both values are necessary, but at most, privacy takes away from security or produces sort of a false feeling of security. Moving then as sort of a more combinational model, security balanced with privacy, recognizing that both values are important, but they are still in tension with one another. So we can think of the Supreme Court cases on sniffer dogs, with the Supreme Court saying, well, this is an important law enforcement mechanism, and yet we have individual rights as well. So I want to reshape the debate and think about how privacy might be complementary with cybersecurity and, in fact, work for cybersecurity. So my premise is that for private sector data-related threats, privacy and security are more often now working together rather than as a conflict. Okay, so if we look at the Minister of Democratic Institutions mandate letter, there was a note to analyze risks to Canada's political and electoral activities from hackers. And so we thought of this in terms of data breaches, probably. But another aspect of this is how privacy weaknesses also are enabling data-related electoral threats. And so what I'm thinking of here is our privacy-weak systems, which have created mass data collection, thus enabling voter ID theft, voter influence, and voter susceptibility to disinformation. So if we think of mass data and data analytics as effectively a precondition that is allowing cybersecurity risks. And we can divide this into two privacy law-related weaknesses. One is the specific under-regulation of political parties, campaigns, and campaign consultants. And the second is problems with weak privacy regulation more generally. Okay, so for those of you who aren't immersed in privacy law, most data protection statutes are based on 10 fair information principles, which you see before you, working off ideas like having access to your information, having the company that collects it be accountable, being able to challenge compliance and correct your information. Principle 3 has by and large carried the weight of privacy protections. So it's this idea of consent, and once the companies got consent, it was largely then fair game for collecting and disclosing and reselling and reusing information. The problem, however, is that in the context of online data, consent is really not meaningful for a variety of reasons. Consent has never been at the level of informed consent of the type that we would see in the health sector. People really do not understand what types of data they are sharing, how it's being put together, what the inferences are online. So it isn't functioning as a free and informed type of consent when users interact with social media. And by and large, users treat social media as fairly benign. They give mass amounts of information. They tend not to download what information, when that's now become available, is held by them. They don't appreciate the massive amounts of personal information. They don't appreciate how many sources are being collated together. They don't appreciate the increasing sophistication of big data analytics and artificial intelligence to put more inferences in the hands of both the social media companies as well as the third-party advertisers. A good example of the problems that we're seeing now is that Canadian researchers recently discovered a problem with Google and court records. So court records are often anonymized for particular categories of either juvenile accused, victims of particular crimes like sexual assault, family law, etc. So there are categories of cases that are recognized as having enhanced sensitivities from a privacy perspective. What is happening with Google's sophisticated algorithm is that these private, anonymized court records are getting matched up when people put a query of that person's name, because the surrounding queries sequentially have produced the ability to relink these. So it's not that these documents have become re-identified, it's the algorithm that is connecting them and thus getting rid of effectively what we thought was privacy protections that the court has put in. Now, the GDPR has come up with some enhanced privacy protections beyond what we have in our current data protection regulations that attempt to deal with the additional privacy protections that are needed from automated processing and artificial intelligence. I'll talk in a bit about how that model may not be totally sufficient either. Okay, so I call this data promiscuity. So we've got an ecosystem effectively that is allowing the mass collection of personal information, the sharing and resharing of that, pairing it with big data and analytics, creating more tempting online targets, creating the possibility of more data breaches, as we've been seeing. And each time that happens, of course, it produces more information that then can be used for other purposes. So this is a visualization from Information is Beautiful that does these lovely graphics of facts online. The red here is defined as being data breaches as a result of hacking. The pink is data breaches as a result of poor security. But it's also important to note that on top of this, we get things like Cambridge Analytica, which wasn't really a breach. That was just a result of really bad privacy policies that allowed this flow of information. So currently in our ecosystem, mass collection of personal data isn't a glitch, it is a feature. With Cambridge Analytica, it wasn't a breach so much as a predictable result of how these companies are operating, what their third-party advertising model is, what their revenue and business model is. So regardless of the mechanism, whether it's hacking in the traditional sense, the result is a massive amount of personal information that can then be used to influence elections. So we've got also a commodification of voter data and voter intelligence. So we're at the point now where it doesn't really make sense to talk about voter data. I have that in my title. But really, the same processes are used with voter data and with consumer data. Indeed, the political parties and the campaign consultants are purchasing consumer data and then selling it to the political parties, and the political parties are assuming the same models of persuasiveness and drawing inferences from the consumer data that one would expect from pure political data. And so this is resulting from gaps in our data protection legal framework. The self-regulation of political parties is really not adequate in terms of the privacy. We've got a larger problem in general of data collection from social media, which is then getting fed back to political parties, and increasing the risks of misuse and improper disclosure of personal information. The most obvious way to protect this, particularly the personal information held by parties, would seem to be to impose privacy legislation on them. So to say, let's take those fair information principles, impose them on the parties, which isn't currently done. But that probably is not going to be as good a system as we might expect it to be. We've got a lot of unknowns. We don't know the political parties' privacy practices. They're not required to publish them. They have ones attached to their websites, but not more generally. We don't know with any specificity what information they collect, from what sources, with what security, nor what they do with it, whether they resell it. We don't know how it's shared between the federal and provincial parties and the data sharing agreements, who has access to that data, how many volunteers can look at those databases, they can look up their neighbors, et cetera. We don't know the encryption that's used, and we don't know if there's many breaches under the current system. We have these unknowns because they don't have fair information principles imposed on them right now. So there is no privacy policy requirement that says they have to say what they're doing with the data and let voters know what they currently have. So there's two gaps currently. The Canada Elections Act does not specifically regulate voter privacy. There's a system in terms of the information that is provided, basic information that is provided to parties, but on top of that, the campaigns and candidates buy and sell a lot of information beyond that. On top of that, both our public sector and private sector privacy legislation are not imposed on political parties. So the Privacy Act, which governs the public sector, doesn't apply to political parties because political parties are not government as it's defined. It also doesn't apply to the private sector because that controls commercial activities, which probably does not apply to campaigns either. So if we try to think what the reform might be, it would have to tackle several problems. The ideal would be to have privacy-sensitive security. So no longer seeing it as an either-or, we need to choose security or privacy. It's not the case where the only option is to increase surveillance and monitoring to obtain higher security and to lose privacy. We're in a system now that the more we protect privacy online, the better cybersecurity we'll have relative to personal information. So if we can reduce the amount of indiscriminate data collection that we have and the amount of information that's swirling in this data ecosystem, it would help cybersecurity. Okay, so two possibilities in terms of regulating voter privacy. One would be to expand the scope of regulated entities under the current privacy legislation, likely the private sector legislation. Or we could create new legislation and put it either under the jurisdiction of the privacy commissioners or the elections officer. The privacy commissioners have issued a consolidated statement that they think political parties are a real issue in terms of a lack of regulation of voter privacy. If we were to do that, it would improve the situation, but we would still have privacy gaps remaining, even with fair information principles. So one problem is the difference between data and inferences from the data. So the GDPR goes some way to trying to address that. Our current fair information principles really do not address the inference part. We address what data is collected, disclose the data, but not what we're doing. So Amazon, for example, needs to tell you what purchases they're storing about you, your credit cards, your shipping addresses. They don't need to tell you that they put you in a category that likes cookbooks or whatever more negative category you might be in. The other problem is if we were to move to a GDPR type system, which would enhance protections arising from automated processing, it would likely be a short-term solution. So it would address what we currently have in terms of analytics and the technologies available. It may not provide longer-term solution as new technologies arise as to how we analyze this information. So how would we rethink the online data ecosystem? So after I'd already done my slides, Tim Cook gave this lovely talk recently, which you may have seen, which effectively talked about this exact issue. And so he referred to the data industrial complex. noting that our own information from the everyday to the deeply personal is being weaponized against us with military efficiency. So one glib response to this is, well, Apple doesn't have this as their business model, and so it makes business sense for him to criticize what Google and Facebook are doing. But if we look at it more sophisticatedly, Apple could have had that business model and chose not to. I actually think Tim Cook is exactly right. This is something Steve Jobs talked about in 2010 about the importance of privacy. So Cook's solution is 4 essential rights: the rights to have personal data minimized, the right to knowledge, the right to access, and the right to security. My own variation would provide, I think, stronger rights. So some guidelines. We should not assume social media data practices are benign. A lot of this is a matter of education. For example, schools are putting kids on Google platform. They're not doing much to protect their privacy. They're doing it with identified accounts with their names at such and such school. We should require consent more on a best interest standard, particularly for people making decisions as custodians, whether that be parents or others. We shouldn't rely on the tech sector's idea of what constitutes consent, but we should upgrade consent to something closer to a free and informed standard that the health sector uses. We should limit collection to what is required for the user to benefit from that service. I'm willing to say the vast majority of information that is collected and stored about you does not help you relative to the service that you're trying to get. So when Facebook gives you surveys and polls, et cetera, that's just pure information grabs. It doesn't help you to get a better service. We should prevent, as much as possible, reselling and third-party uses without explicit permission. It was a long time ago now that I wrote my Master of Laws thesis, and I did it on online profiling at the time. And I suggested using either IP or property as a mechanism instrumentally to provide privacy protection. That debate, I think, is still really salient. If we recognize individuals having rights in their own data and not limited to a right just to see what data is collected or just to be able to correct it, and to recognize a strong right of proprietary right that permission is needed to collect and to use and to reuse their data, to effectuate privacy through property, I think we'd have a much stronger privacy system, but also a much stronger security system as well.